Let me know when it shows up, and hopefully in presentation mode.
We can see it. You're not in presentation mode. You need to click the presentation. Yep, that one. Beautiful. It looks great.
Good.
Thanks.
Okay. Well, let me just say it's a pleasure to be with all of you, and we're doing this virtually again. I've been looking for silver linings in our COVID experience, and I think certainly one of them is that we've learned to be adaptable and flexible, better at that than maybe we've ever been before, and we've learned that it's okay to go to plan B or plan C if necessary. And that's what we're doing again today. And as nice as it would be to be all in the same room together, I'm happy that we have this opportunity to participate together, even if it's virtually. So let me get started. We're going to talk today about the local government entity drug-free workplace policy statute. And let me just tell you how governmental entities are defined for purposes of that statute. I've given you the citation to the statute, but governmental entity for purposes of this statute includes political subdivisions, counties, municipalities, school districts, local districts, special service districts, and administrative subdivisions. So I think it covers most of you that would be participating with us today. So that statute allows, but does not require, a local governmental entity to drug test in the following circumstances. And I'm just going to go through each of these so that you've got them in your head, and then we'll talk about them specifically. So the first is pre-employment hiring or volunteer selection procedures. Drug testing is permitted. Post-accident investigations, reasonable suspicion situations, pre-announced periodic testing, rehabilitation programs, random testing for safety sensitive positions, and to comply with the Federal Drug-Free Workplace Act of 1988 or any other federally required drug policies. Now, the statute's very particular and specific, and it says that you can drug test if you wish, but you have to have a written policy, and it has to be distributed to all of your employees and volunteers, and it must be available for prospective employees. And you have to follow your policy, right? I came across a story the other day. I tucked it away. It's a story of an elderly couple that drove into their 90s, and their adult son asked them how they'd been successful at driving together all those years. And they said that they never made a left turn. They always made 3 rights. And they learned that turning left into oncoming traffic was dangerous. And so they pursued the course of 3 rights instead of a left. And so I thought that that was appropriate here. Don't try to short circuit anything. Make sure that your policy, your written policy, is followed. Every T crossed and every I dotted. Take the 3 rights instead of the quick left. So what's required of the policy? And the statute itself tells you, and so I refer you there. There's policy requirements, but let me go through a few of them just so that you understand. The policy does say, your policy needs to say, and the statute says that an employee has to give a split urine sample. And the reason for that is if there is a positive test on the first sample that's taken, then the split sample can also be tested, and the cost for that sample, the test of the second sample, would be shared between the employer and the employee. But you need to do the split sample testing. And again, it's the employee's option to test the second sample if they're advised that the first sample was a positive. Of course, you've got to employ the services of someone reputable who does this, that is going to, and is independent from you. So you don't want to undertake the drug testing yourself. You want to have an independent entity that addresses, knows how to address privacy concerns, knows how to address appropriate handling of the samples themselves. You need to pay your employees for their testing time. And typically the testing should be at the conclusion of a work day or during their regular work time, and you will pay them for it. The records that you maintain need to be maintained as you would any other medical records. And please, as a reminder, your medical records on employees should never be just tucked into their personnel file. Occasionally I see that when we're defending a case and we're involved in the litigation, and I'm asking for the employee's personnel file. I get the personnel file, it has a lot of medical information in it. So remember that medical information needs to be kept separate. And that's the case with respect to any drug testing results. And the statute also is very clear that if an employee refuses to give a sample, that is considered a positive drug test. So let's go to the specifics, the types of tests that you can do. And the first one is a pre-employment drug screen. This one is probably the least controversial and most regularly conducted drug test. But you can run afoul of the Americans with Disabilities Act because you may be acquiring information about an employee's health that either leads you to conclude that they're disabled or to perceive them to be disabled. So being mindful of the Americans with Disabilities Act, it's always my recommendation that you make a conditional job offer before you do the drug testing. And that's easy to do. You're going to put in writing to the employee or the prospective employee that their offer with the city or whatever your entity is conditioned upon them passing the drug screen. And so you're going to lay that out there. And then you'll explain that if they have a positive drug screen, then the conditional offer will be withdrawn. I just think that's the very best practice with respect to pre-employment drug screens. And you all are probably quite familiar with that. The next one is post-accident investigations. And I guess one of the things that I think is most important here is that you establish parameters and put it in your policy for when you're going to test. Are you going to test, for example, anytime there is an accident involving a motor vehicle? Are you going to test every time there's an accident involving heavy machinery? You've got to establish those parameters and make sure that they're clear. You know, if somebody, paper cuts don't qualify, right? But if someone smashes a hand in a piece of equipment, then you're likely going to want to establish the parameters for that post-accident investigation and testing. And critically important here is that after an accident happens and is reported, and your policy should require all of your employees to immediately report any accident, that drug screening or the drug test takes place immediately thereafter. And a lot of times that can be taken care of at a facility where you may be referring an employee for a work med evaluation. But I would say just be conscientious of the parameters under which you're going to have that post-accident testing. The next type of testing is reasonable suspicion testing. And the statute itself does talk about what reasonable suspicion is. I'm going to read you the definition, and then I'll put up on the screen some language that's come from the Utah Court of Appeals that I think is helpful. So it says reasonable suspicion, this is from the statute, means an articulated belief based on the recorded specific facts and reasonable inferences drawn from those facts that a local government employee or volunteer is in violation of the Drug-Free Workplace Act. It's important, the word recorded. So it's an articulated belief based on the recorded specific facts and reasonable inferences. And I think what's important here is that it needs to be recorded. I'm not suggesting it has to be an audio recording, but recorded in writing the specific facts and the reasonable inferences drawn from those that lead you to believe that the employee may have been under the influence of drugs. And whoever is available and can weigh in on that, if it's a supervisor, whoever, co-employees, information needs to be taken from those people and memorialized. This is what the Utah Court of Appeals recently said about reasonable suspicion in connection with drug testing. And it said, look, we're just going to apply the same standard that we apply for in the criminal context. Reasonable suspicion exists when an observer is able to point to specific and articulable facts, which taken together with rational inferences from those facts, reasonably warrant the intrusion. And that's important, right? It's an intrusion to do a drug test on someone. So you've got to have information that leads you to believe, information that can be articulated, specific information that can be articulated to show that given the totality of circumstances, and this is the rest of what the court said, that further investigation was warranted. So that's what you're going to need for reasonable suspicion testing. Okay, pre-announced periodic testing. So this is both pre-announced and pre-selected. So you say on this day, and these people are going to be drug tested, and you're allowed to do that on a regular schedule. I don't see that happening all that often, but it is certainly an option if you decide to do that. Rehabilitation programs. So this is unannounced, but pre-selected. So this would be a situation where you have an employee who may have had some problems in the past, and as part of their program to continue to work for you, you put them on a rehabilitation program where they are tested. Again, it doesn't have to be announced, it's not scheduled, but unannounced, but pre-selected. So these people have already been identified, and within a range of time, you're going to test them on a regular basis. It's going to be part of like a counseling program or a treatment program. Now, random testing in safety sensitive positions is unannounced testing, right? Okay, so it's unannounced, and it's also not pre-selected. So you're going to select randomly. And the only way you can select, it just has to be random with respect to a certain position, okay? So the statute says specifically that the method used to identify who's going to be tested has to be uninfluenced by any personal characteristics other than job category. So by way of example, we're going to test everybody in our public safety department, and it's going to be random, but everybody in that department is going to be tested. So again, random testing, unannounced, and you're not going to specify who, except that it's within that that job category. And again, maybe you're going to say we're not going to test everybody. Let me correct that. Not everyone who's in public safety, but we're going to randomly choose from employees in public safety to be tested. The safety sensitive positions is also defined by the statute, and essentially the long and short of it is it's anybody who affects the safety of either their employees or the public. So that's how you would decide on the safety sensitive positions. And then the last is to comply with the Federal Drug-Free Workplace Act of 1988 or other federally required drug policies. So maybe a situation where you have a contract with the federal government, the government's is providing you with some financial resources and you have an obligation to drug test. So those are the circumstances under which you're going to do drug testing. And I wanted to talk just briefly, I think we've talked about this and talked about it, but I wanted to make sure that everyone was aware of the Utah Medical Cannabis Act and its importance to you specifically. The state or a political subdivision, any employee who has a medical cannabis card can't be subjected to adverse action. So a termination, a demotion, a reduction in pay for failing a drug test due to that marijuana without evidence that the employee was impaired or otherwise affected in the employee's job performance due to the use of the medical cannabis. So if you get a positive drug screen from an employee and they show their medical cannabis card, you're going to have to accept that and not take any adverse action against them unless they were impaired or otherwise affected in their job performance. And it's going to be important that you can articulate in very specific fashion how that person's job performance was impaired or affected. Now remember, that section, that is no adverse action, does not apply if it would jeopardize your federal funding or a federal security clearance or any other federal background determination. So if this employee works in an area where federal funding is an issue, federal security clearance, where federal background is required, then we just follow the regular federal regulations, and the employees having a medical cannabis card is not going to be a get out of jail free card. That's kind of an overview, and I'm wondering if at this point anyone has any questions. Perhaps we can tackle those first. And then I'm going to move on and talk with just our remaining time with you about vaccinations. I know this wasn't advertised as a subject that we talk about today, but I've been getting a number of questions about that, and I thought it would be worth our time to spend a few minutes on that. So any questions?
Looks like we don't have questions at this point. Just had one.
Okay.
Yeah.
Oh, go ahead.
No, I just had one thing I need to follow up on. So no, we're good.
Okay, let me talk to you a little bit about vaccinations then. And like I say, I've been getting a lot of questions from employers about what to do with respect to the vaccination, and specifically whether or not it should be required of employees. And the notion of requiring people to be vaccinated is not new. The Supreme Court back in 1905 said that it would be an appropriate using police power, it would be appropriate for the state to mandate the vaccination of everyone. And this was during the smallpox epidemic. That, of course, was a pandemic where, hundreds of thousands of people were killed and falling prey to it. But the Supreme Court said, yeah, under those circumstances, we're going to mandate vaccines. COVID-19 isn't that situation, but the EEOC has defined COVID-19 as a direct threat. And so for that reason, there is sort of a reduced burden on the part of employers to accommodate people who are not vaccinated. That having been said, I'm going to just tell you what my opinion is on the front end, and then I'll explain why. I think for most of your employees, it's going to be easier if you promote the idea of vaccinations, but you don't require it. And here's the reason why. So, and depending upon the area in which your employees are working, it may be a situation where they need to be vaccinated, right? Your public safety people may need to be vaccinated. And that's not a problem because, as I say, the EEOC has identified COVID-19 as a direct threat, but you're still going to have to assess on a case-by-case basis an employee who comes to you and says, okay, I know you want everybody vaccinated, but here are the reasons why I can't be or I don't want to be. And there's really two laws that have implication here. One is Title VII, because you could have someone that has a religious belief, a sincerely held religious belief, or a practice or observance that keeps them from getting a vaccine. And if that's the case, then the question will become, should you and can you accommodate that person's religious belief against vaccinations? Or would be an undue hardship for you as an employer to do that? And you're going to have to do some balancing there. The other law that comes into play here is the Americans with Disabilities Act. And what I think we're seeing is people coming and saying, well, I know that I'm supposed to be vaccinated, but I don't want to be because I have, for example, a vaccine allergy, or I have some other disability that keeps me from getting the vaccine, or I have just some other reason that's supported by a doctor's note. And then the question is going to become, it's the balancing that you always do under the Americans with Disabilities Act analysis. Is there a legitimate, is there a legitimate reason to refuse the vaccine? This is what the employees provided to you. And then you have to do a reasonable accommodation analysis. Can the employee perform the essential functions of the job without risking coworker safety and the public safety, and by posing an undue hardship on you as the employer? And or is a reasonable accommodation possible? And we actually have a case out, which is interesting. This came from the Fifth Circuit. It was a firefighter, and he requested some accommodations related to the vaccine, and the city ended up saying, well, if you can't be vaccinated, then we're going to have to put you on a slightly different work schedule, one that to him at least was less desirable. You're going to have to always wear a respirator, and you're going to have to be tested regularly. And the employee challenged that. So this is the employer saying, this is the reasonable accommodation we'll allow. You don't have to be vaccinated because you've got this disability, but you're going to work a different schedule, you're going to wear a respirator, and you're going to be tested regularly. And the employee challenged that and said, no, I shouldn't have to jump through all those hoops. In the court, and again, this is the Fifth Circuit, it's a case that just came out January of 2021, said, no, that was a reasonable accommodation to have the firefighter conduct himself slightly differently. And with those parameters, he either had to take it or leave it, right? So he wasn't vaccinated, but he had to jump through all those hoops in order to maintain his job. So I just want you to be tuned into that. I have provided you here. That's a link to something that the EEOC put together, and they've been adding to it. This came out about last March, and the EEOC has been answering COVID-related questions. They're now to Section K, and it's really, really long, but Section K, that's why I put C Section K. Jump to the end of it, because there's 4, 5, or 6 pages of questions related to vaccines, and it explains the vaccines that are in play right now. They haven't been licensed. They're subject to an executive, it's an emergency provision that allows these vaccines to go forward, even though they haven't been licensed already. But that creates some problems just on its own in terms of requiring people to make use of a vaccine that hasn't been licensed. So you've got to carefully decide, is it a public safety issue where we have to have a certain group of employees vaccinated? And if you do, and you draw that conclusion, that's fine, but you just got to know you may have requests for accommodations from some of those employees. And the 2 most critical areas that you'll be looking at are the Americans with Disabilities Act, and then of course, Title VII under and religious discrimination. But that link I found really, really helpful. It's a question and answer kind of thing. And I think it would be useful for you if you have questions about that. Any other questions?
Yeah, as soon as I said we didn't have any questions, they all decided to pop up. So first question, when is DOT testing required and when is it not?
I guess I'm not sure I understand the question. The Department of Transportation would depend upon what the position is, what their regulations say. I'm not familiar enough with the DOT regulations to know for certain. Is it a situation where the entity has a contract with the Department of Transportation? certification?
No, it would be for CDL drivers. I'll take a shot at it. Just that's a question that
Okay.
we get fairly regularly. This is the non-attorney shot at this. So, but
I don't know off the top of my head. Yeah.
if they are a CDL operator, so they're a driver and they are actively driving, then they would be required under that DOT testing regimen to do that. So if somebody who the example where they would not be required is, let's say I have a manager of a department, a public works department, and they have a CDL, but they don't ever drive, or maybe it's somebody in an administrative position that never drives. They could be removed from that random DOT testing process. So.
And I would just add there, make sure it's a pitch for things that I end up seeing problems with sometimes. Make sure that your job description accurately reflects what's required of these employees. So if they need to be able to drive, then you need to say that. If they don't have to drive, that's fine too. But if they need to drive, get it in there. Make sure that they accurately reflect what's required of them.
Great point. Do you have any examples of reasonable suspicion?
Well, we can make one up. So an example of reasonable suspicion would be someone that's slurring their speech, by way of example. They're falling asleep. It's that kind of thing. And again, those are the kinds of observations that need to be memorialized ASAP after the accident, or as you're developing reasonable suspicion. We don't want to rely upon someone's memory 2 weeks down the road. But if an employee sees an issue like that, they reach out to their supervisor and say, so-and-so's falling asleep, she's been slurring her speech all morning, then I think we jump on that and we make notes of it. The supervisor gets involved to see what's going on, talks to the employee to figure out what's happening. And it may be a situation where we refer the employee to be tested, or the employee may have an appropriate, explanation for it. Again, supervisors doing their job is critically important here, right? Because if it happens next week and the week after, or every other day, and there's a pattern developing, you really have to rely upon your supervisors to identify that for you, so that they can say, okay, it's finally time. We need to do some testing on this employee.
Great.
And I would just, Jason, I would just add to that your supervisors that are making this determination need to have had some training ahead of time. And so when it comes to what's an example of reasonable suspicion, they will be given the criteria, how to look for that, how to identify that as part of that training that they should have before they are, put in a position where they may need to make that call.
And that was the direction I was going on that. We do offer the reasonable suspicion training, and those supervisors need to have that prior to making a reasonable suspicion determination. And if it is for DOT, they need to have 2 hours of training, one on drugs and one on alcohol, and we kind of combine those into one overall session. So if you are interested in that, just let the loss prevention team know on that. Here's a really good.
Go ahead. I was just going to say, make sure your supervisors know to whom they can reach out with questions, right? Is it the HR director for the city, or who is it? Because a lot of times you're thinking, am I looking at this correctly? Is there something really wrong going on? Or did I just, somebody that they can bounce the ideas off of, and someone who has a little bit more experience. So whoever it is, make sure they know they have an outlet, somebody else that they can talk to about this without breaching privacy and confidentiality. So thinking about that.
Yeah, great point. And also for employees, if they have questions about your drug testing as well, there needs to be a designated employee representative there, or employer representative to the employees. Great question here. Mary asks, if you do random testing on EMTs, emergency medical technicians, who are paid volunteers, does this have to be done right before or after performing a safety sensitive function? When they are volunteers, this is difficult.
Okay, so this is random on an EMT, and I think that the statute says specifically that the testing ought to be done either right before or right after. Let me read it. And I think, and it's going to apply to your volunteers as well. Let's see. Let's see. No, I just read it this morning. Let's see, here it is right here. Okay, so it's 3441-104, subsection 5. It says the testing shall occur during or immediately after the regular work period of the employee or volunteer and shall be considered as work time for purposes of compensation and benefits. So that's straight from the statute. Occur during or immediately after the regular work period of the volunteer.
So Camille, can I just take that a step? So let's say I've got a volunteer fire department, and we have to ensure that they are before or during performance of these duties. Could we make arrangements with our testing agency and have it on the drill night? Most of our fire departments have a night when they're scheduled to come in and do their regular training. We could probably do those random tests then. Would that work?
I think that's a good idea, because it's a time that they're obligated to you. Yeah. You expect them to come prepared to work and drug-free. And so I think that makes good sense. I like that idea. Okay. And then again, there's going to be some method for that random selection. You may have said we're going to do all of our volunteer EMTs, and then who gets picked is, you just got to come up with a random way to do that.
And in most cases, that's done through the testing agency. We give them a list of our drivers or our employees, and they do the
Excellent.
Random. Go ahead, Doug.
And there's also a requirement, I believe, you can correct me if I'm wrong, Camille, but for when the individual is required to be ready to perform a safety sensitive function. For example, when that EMT is on call and they're required to be ready to serve, couldn't you also do a random testing during that time when they're supposed to be on call?
Yeah, I think you could. And I think if you did, then you'd consider it as paid time, right? So if you use the on-call time for purposes of that, you'd have to pay them pursuant to your on-call pay schedule.
Okay, looks like one other question. What medications and prescriptions should an employer be notified of, and how does the employer retain that information? So I think what they're getting at is employee has some medical issue and they're given a prescription. Are they obligated to let their employer know that they're using that?
Yeah, if it's going to affect their ability to safely perform their job. So remember, people, there's lots of drugs that are not illegal that people can take, right? This isn't a prohibition on taking a medication that you need for your health. But if it has the propensity to affect, for example, your decision making, your reaction time, then an employee should have somebody that they can notify. And this is where it gets tricky, right? So we want to make sure that the person in possession of that information knows what to do with it. Sometimes an employee goes to their supervisor. The supervisors need to be trained that information is confidential, it's private information. The Human Resources Department would know about it. If there's any documents related to the employee's use of a medication, it needs to be not in the personnel file, but in the separate medical file that you're keeping. And again, all of this is so that we stay in compliance with the Americans with Disabilities Act, right? Because this information may identify a disability of this person. And so being mindful of who has access to that information and keeping it, appropriately maintained. But a lot of times when I'm drafting a policy, for example, and I don't know if you've got a standard one you're using right now, but it'll say that if, we have a drug and alcohol-free workplace policy, right? But it'll say something to the effect of, if you're taking a prescribed drug and you're using it in accordance with the prescription, you're not overdosing on it. But if it has the propensity to affect your decision-making, your ability to do your job, you have an obligation to notify whomever, right? And then the question will become, can we reasonably accommodate this person? They may well be disabled by virtue of this condition. Can we accommodate them?
Yeah.
And like we always say, it depends, right? Are they taking the drug for a week? Are they taking it for a lifetime? How does it affect them? Can they adjust their treatment, when they take it so that they're not impacted during work? It always depends.
Yeah.
Sorry.
Yeah, no, that's a great point. And it doesn't have to be a prescription either. I mean, somebody that takes Benadryl could be impacted just as much as somebody taking an opioid. So.
And letting your supervisor know so that they don't put you in harm's way or put other employees or the public in harm's way is critically important. I guess one thing that's coming to my mind right now is that education of these supervisors is really important because they're in possession of a lot of information and they need to know what to do with it.
Sure. Great information. Thank you so much, Camille, for this information. It looks like that's all the questions. You have a final word for us? Well,
no, it's just a pleasure to be with you. I wish everyone, good health and prosperity and happiness in 2021. I hope it's a good year for everyone.
Thank you so much. We really appreciate your presentation today. And thanks, folks, for tuning in today. If you have questions, don't hesitate to give us a call. We're happy to help out. And thank you so much. Have a safe day.
Thank you.
Awesome, Camille. That was excellent.